we just did mock trials. 36 district on Saturday for Wednesday. Judge Oakley offered to watch start using this. Yeah. It's probably a small, except staff. Yeah, they're doing prelim exams, but almost everything else has been moved to Zoom. It's just like. You guys have these. So I'm good on that one.
Did I send you input?
Yeah.
You did it to him?
Okay. Then I guess I'm not sure who the other, I must have one.
Teresa
I've
Thurman.
got Teresa Thurman. That's
Yes.
what.
Yeah.
And then I think Jeff's is the other one. Anyways.
Yeah, and Jeff's here.
This operation.
Make sure my name will appear once.
How you liking the job?
Change of pace is good.
You came from,
You're 25 years there.
you watched mine.
And I was saying, I think that one of the, maybe not one of the last call, but I remember Grant's up with that. You get dropped off, you get dropped off on the bus or something.
I don't want to get mortgage from neighbors, freshman farming, freshman plant. Yeah. A lot of guys come over and shoot in the back and rage. So, first time I ever met, here. And drive too loud. See, there, it's like a quarter. We walk back. I had military guys back there. Walk to the edge of the woods, and then there's a big clearing, and everybody shoots. And you're fine. Turn around, walk back.
Yeah, I think you're directed by the Christmas tree farm.
Yeah, I was go to east.
No, isn't there, look up facing him, the couple doors down.
Maybe no.
His brother was Rosie Hall.
I know, we got 2 doors out and has an automatic license.
Yeah.
Because he shoots automatic rounds all the time. He's got an FFA.
Yeah.
All right.
He makes sure all of them.
Report district court's now in session. The Honorable Lisa Martin.
You may be seated.
How do things go on Thursday and Friday? Was it?
Good, yeah. It was a little off.
Good morning, sir.
Good morning.
How are you?
I'm fine, thank you.
You ready with Mr. Johnson?
Yes, Your Honor.
This is 220792 OD. This would be City of Romulus versus Andre Johnson. May I have your appearances, please?
Your Honor, for the record, Jeffrey Bowden, 45367, hearing on behalf of and with Mr. Johnson. Sir, could you tell the judge your name for the record, please?
Andre Johnson.
Thank you, Mr. Johnson. Today,
Your Honor, today is the date time set for sentencing in this matter. I've met with Mr. Johnson. I have reviewed with Mr. Johnson the pre-sentence report. We find it almost factually accurate. There would be one addition. Mr. Johnson has changed his address, Your Honor.
Mr. Johnson, have you provided the updated address to Mr. Grant this morning?
Not yet, ma'am.
Before you leave the courtroom, you'll meet with Mr. Grant and give him that updated information, okay?
Yes, ma'am.
Thank you.
Other than that, Your Honor, we find the report factually accurate. No additions, no deletions, no corrections. We might have a slight comment about issues 6 and 7.
Make your comment now, please, Mr. Bowditch.
Well, Your Honor, Mr. Johnson works a lot of hours, and item 6, I believe, is the community service. Item 7 is the council, and we've discussed all that, or the alcohol education is number 7. He thinks he may have a hard time doing his community service. I told him there are things out there that will assist him. As far as number 7, Your Honor, after our discussions, I believe Mr. Johnson believes that education can value him. I'm not sure we have a discussion about that anymore.
Okay. Anything else?
No, ma'am, that'd be.
Thank you. Mr. Johnson, anything you'd like to say on your own behalf, sir?
No, ma'am, besides, he covered everything. I do work a lot of hours. I try to pick up on Saturdays to get extra overtime. Other than that, that's pretty much it. So-
Okay. The court has had the opportunity to review the PSI prepared by probation officer Anthony Grant and will indicate for the record that there was an offense date in this case of October 15, 2022 in the city of Romulus, which time Mr. Johnson was found to be operating a motor vehicle with a blood alcohol content of 0.163. He appeared before this court on September 7, 2023 and entered a plea of guilty to the reduced count of operating while visibly impaired. The court has had the opportunity to review the police report in its entirety. Will indicate for the record that this is Mr. Johnson's first alcohol-related offense. And the court will adopt the recommendation made by Officer Grant. Will impose a fine of $300, cost of $200. There's $75 mandatory crime victims fee. There's $50 show cause fee, $50 warrant fee, $15 administrative fee, $50 mandatory state cost, $20 fund fee, $45 clearance fee. Mr. Johnson will be placed on 9 months of probation with the associated oversight fees of $360. He will pay restitution of $200 to the city of Romulus. He will complete 24 hours of community service. Mr. Johnson, you'll have the entirety of your probationary period to do that community service. If you don't already have a relationship with a nonprofit where you can get your hours in, Mr. Grant and Mr. Taylor, who both in this court's probation department have files full of places you can get those hours. And it will be hours you can work around your work schedule, even if you pick up Saturdays from time to time, okay? You'll provide documentation of that community service to Mr. Grant as directed. You will enroll in substance abuse treatment or alcohol education within the next 30 days and follow all recommendations from that program and provide documentation to Mr. Grant. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood-altering substances without the court's approval. And you will submit to random ETG testing a minimum of 2 times per month or as otherwise directed by Mr. Grant. You will make regular monthly payments on the fines and costs that this court has imposed. The court is able to apply the bond that you previously posted to the fines and costs. Mr. Johnson, this court's sentence is to discourage you from reoffending. It is not to be a penalty. We want you to be successful on probation. That means that if there is something that comes up and you're stumbling a little bit, reach out to Mr. Grant when there's a little problem. When it's a big problem, you're either positive on your ETGs or you pick up a new case or something like that. Those are a lot more serious for us to deal with than for you to call Mr. Grant and say, listen, I know I owe 150 for this month, but I only have 100, or hey, I'm short on these community service hours. Can you work with me? It's a lot better if you are proactive and being in contact and communication with him. There will be forms for you to sign to formally put you on probation. Mr. Grant will help you set up a payment plan. Is there anything else, Mr. Bowditch?
Nothing, Your Honor.
Anything else, Mr. Johnson?
No, thank you.
Before you leave and before I call the next case, I'll have you stop with Mr. Grant real quick to give him that updated address, okay?
Yes, ma'am.
Thank you, sir.
Thank
Good
you.
luck to you.
Thank you.
Thank you, sir. Oh, force a habit, thank you. Ms. Platt, this is 230520OD. This is City of Romulus versus Angela Lee Platt.
Morning, Your Honor. Spencer Clayton, hearing on behalf of Ms. Platt, I stand to my right, key number 77302. Your Honor, I'm standing in the attorney of record in this case, which is Mr. Maurice Davis. Ma'am, is that with your permission that I stand in for Mr. Davis for the purpose of today's hearing?
Yes.
Thank you. Can you state your name for the record?
Angela Black.
Thank you, Ms. Platt. Good morning, Mr. Clayton. Today is the day and time set for sentencing in this matter. There was an offense date in this case of May the 6th, 2023, at which time Romulus Police found Ms. Platt to have been involved in a 3-car accident with a blood alcohol content of 0.232. Ms. Platt appeared before this court on September 7, 2023, and entered a plea of guilty to the reduced count of operating while visibly impaired. The original charge was operating with blood alcohol content of 0.17 or more. Ms. Platt was referred to the court's probation department for interview and the development of a sentence recommendation by Officer Anthony Grant. The court has reviewed that recommendation along with the police report. Mr. Clayton, have you had the opportunity to review that PSI with your client?
We did have the opportunity to review the PSI judge. Additions, deletions, or corrections at this time.
Thank you.
And if I may, on her behalf, just briefly, with some allocution.
Absolutely.
Your Honor, as the court I'm sure is already well aware, she doesn't have any priors. She's a single mom. She works. I know she's pretty disappointed in herself. I'm sure, as the court can see. This is a situation she's not going to repeat. She hasn't had a drink since May when this incident occurred. When I'm looking at the recommendation, I see it's kind of focused on 2 things, really: sobriety and some education, as well as community service. I think all those things are appropriate. I think the recommendation is appropriate. I'm just asking the court to adopt it.
Thank you. Ms. Platt. It's okay. When you take a breath, well, wait a second. If there's something you want to say on your own behalf.
I am disappointed. And since the beginning, I have taken full responsibility because I made a poor choice. And I don't know what else to say. Just that I am disappointed in myself. I don't plan on making the same mistake twice. I can't afford to, Yeah, that's it. I just don't know what to say.
No, ma'am, no, listen, it's okay.
Beating myself up.
We all stumble. Unfortunately, you have to live your stumble out loud in a room full of strangers, and I know that's very difficult. But you have taken responsibility. And it's clear from your interview with Mr. Grant that you're aware of how much this is costing you, not just financially, but emotionally. Your response to the accident and everything after that shows that you're taking this seriously. And as much as Mr. Clayton has indicated that he has reviewed the PSI with you and the recommendation is appropriate, the court will adopt the recommendation made by Mr. Grant and will place you on 12 months of probation. with the associated oversight fees. The court will impose a fine of $300. There's cost of $200. There's $75 mandatory crime victims fee. There's $200 in restitution to the city of Romulus, $50 mandatory state costs, $20 fund fee. That's a total of $1,325. You will complete 24 hours of community service at a nonprofit with documentation provided to Mr. Grant as directed. If you don't already have a relationship with a nonprofit, reach out to the probation department. There are files and files of places where you can go and get the hours you can do them virtually or in person, weekday, weekend. Get that done sooner rather than later. You will enroll in substance abuse treatment within 30 days and follow all recommendations from that program and provide the documentation Mr. Grant has requested. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood-altering substances without this court's approval. And you will submit to random ETG testing a minimum of 2 times a month or as otherwise directed by Mr. Grant. You will make regular monthly payments on the fines and costs that the court has imposed. And I know, Ms. Platt, you were in the courtroom when I was speaking to the young man before you. This court wants you to be successful on probation, wants you to learn from the alcohol treatment, the substance abuse treatment, and would ask that if you have any issues completing any of the terms of your probation, that you reach out to Mr. Grant. He's available by phone, he's available by email. He wants you to be successful. I don't want to see you again. If you're feeling like you might stumble a little bit, if you can't reach out to Mr. Davis or Mr. Clayton, reach out to Mr. Grant. We will help you stay on track so that we can get you off of probation sooner rather than later and not see you again in any circumstance, okay? Anything else, Mr. Clayton?
Okay, thank you.
Anything else, Ms. Platt?
Okay.
Good luck to you. Mr. Grant will be in touch with you with forms to sign to put you formally on probation, okay?
Okay.
Thank you, ma'am.
Thank you.
Mr. Hadley,
Good morning, Your Honor.
how are you, sir?
Quite well. You got more me today than you wanted. I'm covering for Mr. Nunley before the violation of probation.
There's never too much of you. What are you talking about?
If I may, let's go ahead, Ms. Teresa Thurman.
Absolutely. This is 230440 SD. This is State of Michigan versus Teresa Thurman. Your appearances, please.
Good morning, Your Honor. Attorney Josh Adley standing in for Brother Counsel, Mr. Royce Nunley, on behalf of the defendant, Ms. Teresa Thurman, who's in person today for the sentencing. Please state your name.
Teresa Thurman.
Thank you, Ms. Thurman. As indicated, today is the day and time set for sentencing in this matter. There was an offense date of July 17, 2022, at which time Huron Township found Ms. Thurman to be operating a motor vehicle while intoxicated. Ms. Thurman appeared before this court on August the 2nd, 2023, and entered a plea of guilty to the reduced count of operating while visibly impaired. The court has had the opportunity to review the sentence recommendation developed by Officer Anthony Grant and review the report in this matter. Mr. Hadley, have you had the opportunity to review that report with Ms. Thurman?
Yes, Your Honor. We did have we did have a chance to go over the report. Outside of the changing of some pronouns that she caught, we have no additions or corrections, nothing factually that was inaccurate. We're ready to make a brief allocution and address the recommended sentence. Court's ready to hear this.
Please proceed, sir.
Your Honor, I'd like to first point out that this was an offense date, as you just noted, of July of 2022. This is Ms. Thurman's first alcohol-related offense. I would note that she's been fully bond compliant, has not had any issues with alcohol, has fully complied with the court's requirements of not consuming alcohol. The reason I point that out, Your Honor, is we do have an ask as it relates to the length of probation. We do see this 9-month recommended period. I would state that because of her compliance with the bond conditions and her, I'll just call it go-getter attitude about getting what's on this list done, we believe a shorter period of probation would be sufficient to address the community's needs as well as allow her to complete the requisites. Otherwise, we'd ask the court to adopt everything else within that and just perhaps consider a 3-month to 6-month period of probation versus the 9 months. I know this court's been very, in past cases, open sometimes to an early discharge upon completion of all requirements. We've addressed that. But really, I think the goal is to get this kind of put behind her as quickly as she can and move forward with her life. She's still gainfully employed. As I pointed out, very remorseful and regretful for what happened, but a law-abiding citizen overall.
Mr. Grant.
Your Honor, I actually don't see a problem if we do a 6-month probation for Mrs. Thurman. If it's okay with you.
That would be a huge, we would appreciate that greatly if the court would agree with probation.
Thank you, Mr. Grant. My note was 6 months as well, so that worked out nicely. Great ask, Mr. Hadley. Other than that amendment, the court will adopt the recommendation made by Mr. Grant. Place Ms. Thurman on 6 months of probation with the associated oversight fees of $240. The court will impose a fine of $300. There's cost of $200. There's $75 mandatory crime victims fee. There's $206 in restitution here on Township. There is $50 mandatory state costs, $20 fund fee. That's $1,091. Ms. Thurman will also complete 24 hours of community service at a nonprofit organization and provide documentation to Mr. Grant as directed. If you don't already have a nonprofit that you're associated with where you can get your hours in, reach out to Mr. Grant or Mr. Taylor in his court's probation department. They have files and files of places where you can get your hours and get those hours done sooner rather than later. You will enroll in substance abuse treatment or alcohol education within 30 days of today's date and follow all recommendations from that program. And again, provide documentation to Mr. Grant as requested and directed. You will not purchase, possess, or consume any alcoholic beverages or non-prescription controlled or mood altering substances without this court's approval, and that you will submit to random ETG testing a minimum of twice per month or as otherwise directed by Mr. Grant. You will make regular monthly payments on the fines and costs that this court has imposed. I know you came in when I was speaking to the young lady before you. This court does not want to penalize you for what happened on July 17, 2022, but this court's goal in this probation and the terms associated is to discourage you from reoffending and appearing here again. If during the course of the next 6 months or shorter, if you're able to complete everything other than your payment of fines and costs, if you find yourself struggling meeting any of the requirements of probation, reach out to Mr. Grant sooner rather than later when it's a small problem. It's a lot easier for us to pivot a little bit and help you over that small hump versus you either stop making payments, don't do your treatment, don't provide documentation as requested, because then Mr. Grant will send you notice to come before me and we'll talk about why you violated probation. So it's a lot easier just to reach out to him and let him know if you need something, some support or some other information. Mr. Hadley, anything else this morning?
No, Your Honor, thank you, Mr. Grant, for hearing us out today, and we appreciate the court's time.
Thank you. Ms. Thurman, good luck to you. Mr. Grant will be in touch with you. There'll be documents for you to sign so that you are formally placed on probation, and you need to set up a payment plan for the fines and costs, okay? Thank you, ma'am. Have a good day.
Thank you, Your Honor.
I was hoping that the files would be it from Andy. I was hoping, Andy has 2 files that should be coming up. They might be ready. Thank you, Mr. Grant. I'll see you at 9:30.
All right, thank you, man. With her, a colleague, she, but if she takes it for 6 months, yeah. You know what I mean?
Because it's stick close, just because you wanted to get your 24 hours or whatever it is that.
Yes, I was just wondering if maybe, I could testify to this is Mr.
Oh, oh, all right.
He's a return.
Oh, all right.
So you can take a test with us if you want today. I have no problem with that. Just so you know, though, the test did come back negative.
Right.
From us.
Yeah, I know that, and I sent it to the lab so that we can
Yeah.
show the numbers are going down, so.
Yeah, So I don't know if you remember his.
Yeah, I did see that one.
So his issue is. Correct.
Keep them for THC
Prior to.
prior to starting probation.
But we're seeing the numbers.
The numbers are dropping.
So the first two, I got tested and outside, he came back positive. He volunteered to come in here and do our program to show that there was a negative in front of judge. Unfortunately, it's still positive.
Right.
And then, but he did get his brand on that onsite and he came back. So at this point, it's a bump in the road.
Yeah.
And get you back on track.
I don't drink much water, that's just serious, but I guess.
Well, you don't want to drink too much because then it comes back.
Yeah. I'm just saying my numbers are going down.
I've seen, these strains, THC is a weird, use effect where I've had people discontinue to use called on a Monday, test on a Tuesday, and then show a higher reading on Thursday.
Yeah.
It will hit its bell curve at some point, but in that first couple of days of like the stopping,
Right.
it's not like the shelf life of cocaine or alcohol. It does, the way it metabolizes is a little bit.
Mhm.
I didn't figure out how to drill down the testing for that. It's gonna be-
Yeah.
Yeah, I'm serious, you determine somebody's stone like on the spot, because of the way that the carboxy, whatever. That'll be the next one, that'll be the next breathalyzer, you can invent that, sir, for all the other private island, man. I'm telling you, it's the thing, but yeah, I'm glad that you guys take that approach of looking at these in that way, because we've had to do evidentiary hearings in Oakland County with stuff, it's like, this test isn't
Right.
for.
Well, and part of it is just talking too much. Because the test itself can be a little bit, even though the numbers are down, he may have just drank a lot more water that previous test. So it may not show what we think it's showing, but talking to him, I believe, it's the truth.
So that's always great, get them to believe you as long as.
I don't want to be here just like he probably don't want me to be here. You know what I'm saying? I mean,
Well,
I'm trying to do everything that I can do. You guys can't.
The whole court's in and out of concern. You guys are the most willing to work for a solution. You know what I mean? You guys are solution based, like, department.
Right.
Yeah. Other courts have remained nameless so much.
Well, I mean, there's gotta be a fine line, right? There's gotta be some accountability, some sort of punishment, but unfortunately, we're in Lake County, so the jail thing just doesn't happen.
I actually, right when I take my onsite test. Well, I mean,
Being truthfulness, obviously, compliance is what you have to have, but being truthful about the situations.
I just want to go back to test today, just
You
to
do it
kind of
now.
show.
We do, you just.
And I brought that extra 15 that I couldn't pay, even on the, when I showed you, I couldn't even pay it on the internet, so they couldn't find my case.
Yeah, you want to?
Yeah, I would like to actually.
And then
And
that's,
I brought that extra 15 to.
okay, let's go downstairs and pay the front pass. Okay. Because I think part of the problem was is that you paid your fire department. So it might not even show. Yeah.
Good morning, Mr. Kaplan.
Good morning, Your Honor.
Andy's on her way in. She will get you connected with the PD and the defendants.
Thank you very much.
Good morning, Lieutenant.
Morning. Do I need to step up?
This is 230800FY, State of Michigan versus Zachary Wyatt. Your appearance, please.
Your Honor, he's not in the courtroom.
Sorry, Mr. Kaplan. Two three zero eight zero zero FY, State of Michigan versus Zachary Wyatt. Your appearance, please.
Joshua Kaplan on behalf of Mr. Wyatt. Mr. Wyatt, we
State your name for me, sir.
I'm Zachary Wyatt.
Thank
Your
you.
Honor,
I'm
for-
sorry, Mr. Kaplan.
No, I appreciate it, Your Honor. And for purposes of arraignment today, we're going to waive formal reading, stand mute to the charges.
Mr. Wyatt, were you able to hear Mr. Kaplan just now?
I missed the whole part, what you just said. I apologize.
He was saying that he's waiving your right to have a reading of the formal complaint against you in this matter and is having you stand mute to the charges.
Oh, yes, Your Honor. I understand.
Thank you, sir. In this felony matter, you have a right to be represented by an attorney. If you're unable to retain an attorney through your own resources or if that family and friends, the court is able to appoint one for you. Attached to the front of your file was a petition for court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Kaplan. It will be someone else who relies on the information you provided to be in contact and communication with you. Sir, you also have a right to be considered for pretrial release. There is a recommendation from Romulus Police Department that your bond be set at $20,000 with 10% posted. And that condition of your bond be that you have no contact with the victim in this case, that being Tammy Callahan, and that you do not use drugs or alcohol during the pendency of this matter. Mr. Kaplan, your comment as to bond.
Yes, Your Honor. I believe this is a pretty heavy bond that is being requested, and there's no, they didn't provide any reasons for it. We have no objection to no drugs or alcohol, and certainly no objection to a no contact with Tammy Callahan. It is a girlfriend. They do live together. I went over with my client that a no contact order means absolutely no contact whatsoever. And he understands that he would need to find alternative places to live, which he has no objection to doing during the pendency of this case. He does work. He's gainfully employed as a painter. He works with his father, who owns a company. He has 3 kids, 13, 15, 17, that he has shared custody with his former partner. I know that he had criminal history in the past, but I believe it's been limited since about 2019. He promised to show up at all future court dates. He plans to remain local and find alternative living in Romulus during the pendency of this case. And so we're requesting a personal bond on this, Your Honor.
Thank you. Mr. Kaplan, this court's only concern, well, one of the concerns is that the petition for court-appointed attorney lists Mr. Wyatt as being unemployed, and you've just indicated on the record that he works for his father as a painter. The court does concur with your assessment, sir, that the bond sounds high. The court does have concern that this is Mr. Wyatt's 3rd domestic violence case. Mr. Wyatt, let me finish my part and then you can say whatever it is you raised your hand to say. The court will set the bond in this matter at 5,000, 10%. There will be two conditions of your bond, two specific conditions, Mr. Wyatt. One, that you do not use drugs or alcohol during the pendency of this matter. Two, that you have absolutely no contact with the complainant, in this case, Tammy Callahan. I know that Mr. Kaplan explained that to you, but sir, no contact means no contact. No direct contact, no contact with third parties, no contact with social media. Should this court receive report that you made efforts to be in contact or communication with Ms. Callahan, it could be viewed as a violation of the terms of your bond, sir. Your bond could be revoked and you could spend the rest of these proceedings in custody. Do you understand what no contact means?
Yes, I do, Your Honor.
Thank you, sir. Your next appearance date will be on Wednesday, November the 1st, 2023 at 8:30 a.m. with Judge Oakley in courtroom number 2. If you have posted your bond, your hearing will be in person. If you are still in custody, it will be by Zoom. Again, this case number is 230800FY. Mr. Wyatt, your hand has been up twice now. If there's something you want to say, not about what happened on October 20th, but if you have a question about these proceedings, why is your hand up, sir?
Yes, I had, thank you, Your Honor. I apologize. The reason why I was asking for a PR bond is because my father is in dire health of trying to finish out this job that he has going on, and I'm the only person that's really helping him. And he comes and picks me up, and we have about 2 weeks left to finish, and it's a pretty big job for him. And there ain't no way for me to pay a bond to get out of jail. And it's keeping me out of trouble. It's keeping me out of harm's way. I'm not gonna be bugging anybody. So if I could get a PR bond, then I can help my dad. I can have some money to pay through the courts for when I come to see you guys too. And it would help me out a lot because it would be keeping me working, keeping me out of jail and out of trouble. I'd rather be making money than be sitting in jail, and I don't have any funds right now because we haven't been able to finish the job.
Respectfully, Mr. Wyatt, Mr. Kaplan has argued on your behalf regarding bond. The court has deviated from the police recommendation. As indicated on the record, the court has concern that this is the third domestic violence case you have. This is quite a lengthy criminal history, sir. And again, on your petition for court-appointed attorney, you list yourself as unemployed, but you're actually working. There is no prosecutor here now to argue on behalf of the people, sir. Your attorney is able to take up your bond issue next Wednesday with Judge Oakley at 8:30 a.m. Anything else, Mr. Kaplan?
No, Your Honor.
Anything else from Romulus?
No, Your Honor.
Thank you. Good luck to you, Mr. Wyatt. Have a good day.
All right, thank you. Domestic violence.
Good morning, Van Buren.
Morning.
We'll get Ms. Raggy moved into a breakout room with Mr. Kaplan.
Okay.
Thank you.
We've got 4 here. They're speaking to Josh, alternating.
Okay.
You want me to bring it? Well, we gotta wait for Josh anyway, so.
I saw that it wasn't quite 9:30 when I came back out, and I thought we could get the 2 arraignments done before you were ready. So I'm sure you watched the Michigan State game.
Yeah, well, it wasn't much of a game, now was it? A lot like the Lion game, wasn't much of a Lions game.
I wasn't watching, but I was hearing the yelling from downstairs, which is the international sign that they weren't doing well.
And I'm waiting for Jackie to show up this morning. The biggest Lions fan in the building.
Is she really?
She-
I did not know that.
Oh, yeah.
I'm starting to give Avery NFL questions every day. Today, or like once a week. Today was what 2 NFL teams have a football in their logo. And then he pulled out a logo from 1961. I was like, no, that doesn't count.
Why are you breaking our nice stuff?
I use broken force.
Well, originally we had the old gray fabric chairs in here.
The what chairs?
The old gray fabric ones with,
Oh, yeah.
there were 3 of those or 4 of those, and one of those pink rolly chairs was the witness chair. I had an officer from Huron who was Mr. Grant's size. He comes in
Well
with
said.
with his gun belt on and tries to sit in that pink chair.
I hated chairs that had the sides where I wear the gun belt. I have to dip in sideways and,
He stays up.
yeah.
Stand up and take the chair
Oh, I
with
did. I've done that, yeah.
you. Mr. Reed's here.
Mr. Reed is here, okay.
So, Josh has 2 more to talk to.
Okay,
Then we'll bring them all in.
okay. We have Mr. Kaplan, the other Josh, with an arraignment that I'm hoping to get done before Josh Hadley is ready.
You'll probably be at least another 10 minutes.
Oh, okay.
The 10-5 or 10-2 hearing. And then just got picked up by Vivian.
Okay. I didn't realize that.
You're up here for Ms. Regi?
Well, that and Mr. Matthews.
Yeah,
I have Mr. Matthews. and
Mr. Metzger. Mm-hmm.
Do you want to calibrate?
It's, yeah, we can do that.
That you want to test tomorrow.
I just gave Mr. Govat.
Especially if we do it Tuesday afternoon. We'll have whoever comes. This jacket came back so quick.
I've had them since last Wednesday, but I had not been in.
Yeah.
As they are just the nicest people to deal with.
They're a design line.
Design line,
Okay.
right there on Belleville Road, across from like McDonald's driveway, kind of, sort of,
Okay.
back behind one of the tire stations.
Oh, okay.
Their catalog is online, because I've ordered other stuff from them. It's just, they already have our logo in. She knows how many stitches it takes, and they charge by the stitch or something.
Yeah.
Because I got a new fleece too. Because the one I have, it's peely and
The one I have is very, well, I guess it's all places, but they collect dog hair pretty easily. Especially that one.
that's why I leave it here.
I'm sorry to leave it here. Do it in the closet or here.
You don't realize how bad it is until you see the cuffs, or with the longer coats, you see the bottom of it. And
We dry clean those 2 times a day. It's ridiculous.
this is 1803330 Van Buren Township versus Kelly Lynn. Is it Reggie?
Reggae, ma'am.
Reggae, thank you, ma'am. Your appearance, please.
Joshua Kaplan on behalf of Ms. Regay. Ms. Regay, will you state your name for the record?
Kelly Reggae.
And Your Honor, for purposes of today's arraignment, we'll waive form reading, stand mute to the charges for the violation of probation.
Thank you, Mr. Kaplan. Just so you're aware, Ms. Rapp, the probation officer, is also here in the courtroom.
Hi, Ms. Rapp.
Mr. Kaplan, you've had the opportunity to speak to Ms. Regay. The court's issue and concern is that this is an older case, 2018, offense date January 12th of 2018. She appeared before Judge Parrott, was sentenced, and has had multiple opportunities to finish out her sentence in this case. The report memo received from Ms. Rapp indicates that Ms. Regay was arraigned by Judge Oakley on September 25th. He placed her on a personal bond with a directive to appear before this court on October 2nd for the violation hearing. She failed to appear on that date, and this court issued a warrant for her. She was scheduled at 9:30. She had not appeared by 9:51. The bench warrant entered again. There's been multitude of bench warrants in this case. She failed to complete the 7 days of the work program that she was ordered to complete. She completed 5. She didn't provide the updated treatment documentation from Haven Wilk or with a wellness center in lieu of the economic crime program, and she's failed to maintain her payment plan. She owes $270. What is your position in regards to the violation?
Yes, Your Honor. I did go over all that stuff. We did receive the report from Ms. Rapp. And I did go over that with her. Your Honor, she was picked up at a motel, I believe. She was not on any drugs or alcohol at the time. She's been homeless, staying at that motel. She was working at GM, but was laid off, and hasn't had a new job since. It's discussing that with her. She did tell me that transportation was the main issue, but she did do 5 days work program. And then obviously I believe that she kind of lost track and forgot about the rest of that. And she understands that is her fault. I know it's also listed that she picked up an OWI in St. Clair Shores. I was on their website. There was nothing showing at the time. She says that case was dismissed. So given the factors, Your Honor, I'm hoping that you would give her a personal bond, so that she may continue to take care of her sick father and her mother, and hopefully get back on her feet while dealing with this case. She promises to show up at all future court dates.
Thank you. Ms. Rapp.
Can I grab the probation file from you? And then that's what it is. To the operating while intoxicated in St. Clair.
Mr. Kaplan, were you able to hear Ms. Rapp?
I could not.
She did plead guilty on June 18th of 2018 for the St. Clair operating while intoxicated.
And I apologize. On their website, when I looked up, when I did a case search, nothing came up on that. That's why. And she told me that it was dismissed. So under reason and belief, that was the only thing I can say. Was it out of 40th District Court?
31st.
Oh, okay. That's 31st. My apologies.
31st Circuit?
Circuit Court.
That's why. Okay.
And then there is a count 3 felony motor vehicle unlawful driving away, which she also pled guilty to.
Understood. Well, Your Honor, given those circumstances, we still believe that we would request a personal bond on this matter, and she does continue to promise to show up at all future court dates.
Ms. Rapp, your recommendation.
Due to the fact the defendant has, I believe, 4 prior failure to appears, and recently, as early as 30 days of prior failure to appear, I'm recommending that it's a 10% bond at Your Honor's discretion.
Thank you. Mr. Kaplan, respectfully, the court will set bond in this matter at 1,000, 10%. As indicated previously, this is a 2018 case. that Ms. Regay has been repeatedly in warrant status. Judge Oakley granted a personal bond. She failed to appear. I understand being laid off and having housing issues, but to fail to be in contact or communication with the court is unacceptable given the age of this matter. Also concerning is that Ms. Regay has incurred newer felony charges and did not disclose that to you, and has actually entered guilty pleas in those cases in a different court. In addition to the bond that was posted, we will set a probation review date for Ms. Regay to become compliant, at least with paying of the fines and costs. This court no longer has a work program. She still owes 2 days on that. But in lieu of the work program, what the court would suggest is hours of community service. Do you have the next probation date handy, Ms. Rapp or Mr. Grant?
I do not.
I believe it's November 2nd.
November 2nd?
Ma'am?
On a Thursday?
That's a Thursday.
That's a Thursday, November 2nd. I'm sorry, we're just looking for the next. Ms. Regay, are you in a position to post $100 to be released?
Ma'am, I have $70 to my name right now, and I have no other way of getting money here. That's all I have. That was for a room, but I can go to my grandfather's house, and I could bring back the $30, but that's all I have is 70. I've tried calling my family. I can't get through to them. I don't know what else to do. That's the only reason I asked for a personal. I really did not mean to miss the court date. I've had a lot going on. There's been times I've had to sleep in a car. I do work. It's just this strike going on right now. Everyone's laid off. So if you could just please, it's just this time, give me a personal or take the $70. I will complete the rest of my probation. I do not get in trouble. I promise. I have changed my life completely. I'm honestly just trying to live.
Respectfully, Ms. Regay, the issue is that you just had a personal bond less than a month ago and failed to appear. The bond will be the 1,000 personal. I'm sorry, the 1,000 10%. I'm just looking for the review date for Mr. Grant. We will get that to Van Buren within the next probably 15 minutes or so. Whatever this court's next probation docket is, we'll set you for review at 9:30 on that date. Is there anything else, Mr. Kaplan?
No, Your Honor. Thank you.
Van Buren, we'll get that date to you momentarily, but other than that, Ms. Regay, good luck to you, ma'am.
Okay, thank you, Your Honor.
Thank you.
Bye-bye.
Andy, is there anything else?
Nothing else in the hopper.
Thank you, ma'am.
I'm here if you guys need it. If not, have a wonderful day.
You too, Mr. Kaplan.
So what are we doing?
They're gone, but when you get it, let me know, so we can write it in the file and get it over to Van Buren. I think it's the 6th for some reason, and you know what, let me get up and go look since Mr. Hadley's not ready yet. I'll be right back.
One of mine is the 13th, for Green and 1 and 9 for Martin. It's either the 13th or 6th. I don't know which judge.
Who's this name?
I don't know. She's
So
kind of
your
normal.
signature not changed.
I keep everything on strap, so it's confusing.
Well,
I didn't.
for me, I give a, we should do the old hidden ball trick like a dog. What are you?
Thursday was a little like.
That's one word for it. I may have used a different word entirely. It may start with an S and end with a show. We got through it.
Yeah.
At the end of the day, now, this is a friendly fix up.
All right.
You may be seated.
Morning, Aaron.
Good morning. That date on Ms. Regay will be November the 13th, 2023 at 9:30 a.m.
Judge, is that in person?
Yes, ma'am.
Thank you.
That wasn't one of the ones that was on today's docket. Was it a VOP from today's docket?
No.
Okay, just making sure I didn't miss somebody on my sheet.
It's one from 2018. Mr. Hadley.
Your Honor, I will go ahead and call them in order as I met with everybody, if that's okay.
Absolutely.
We are here on Brandon DeVito.
230488SD. This is State of Michigan versus DeVito. Your appearances, please.
Morning, Your Honor. Attorney Josh Hadley, being on behalf of probationer defendant, Mr. Brandon DeVito, who stands to my right. Please state your name.
Good morning, Your Honor. I'm Brandon DeVito.
Good morning, Mr. DeVito. Today is the day and time set for the violation of your sentence, sir. There is a memo received from Anthony Grant of the Court's Probation Department dated today, October 23rd, 2023, with the indication that you tested positive for marijuana on August the 26th, 2023, September 11th, 2023, that you have provided the documentation from the substance abuse program, and you've paid off all fines and costs in this matter. You tested positive for marijuana a third time on October 5th, 2023. The probation order that you signed previously with this court indicated that you would not use any non-prescribed controlled substance. Mr. Hadley, what's your position relative to this violation information?
Your Honor, after advising my clients of his rights, we would plead responsible for the technical violation of these tests coming back positive for THC, and we would ask for a brief moment for explanation and allocution.
Absolutely. Please proceed.
Your Honor, it's my understanding that Mr. DeVito has been working with Mr. Grant cooperatively. What we've got was pretty elevated THC that we're now seeing diminish. So it's doing the proper bell curve on the way back down. I believe the reports would be indicative that he has discontinued use. We would just ask that the court continue his probation, or maybe even set a control date out to ensure that these tests are continuing in the right direction, which would be indicative of no more cannabis use.
Thank you. Mr. Grant.
We're fine with that, Your Honor. He did test, he volunteered a test coming here today. Unfortunately, that was a positive test, but then he since tested on site on the 17th. It was a negative, and he volunteered to take a test here with us today before this court hearing today. He's made every effort. I believe that that positive was prior to him starting his probation.
Thank you. Mr. Hadley, the court will accept the plea of responsible to the technical violation, accepts the statements made by Mr. Grant that Mr. DeVito is in fact on the downward trend, will not extend his probation or otherwise penalize him as long as he continues in this downward testing result pattern. Anything else, Mr. Hadley?
No, Your Honor, thank you.
Anything else, Mr. Grant?
No, Your Honor.
Good luck to you, Mr. DeVito. Have a good day.
Your Honor, I next have up ready to go Mr. John Martinez.
Mr. Martinez is 2302940D, City of Romulus versus John Martinez. Your appearances, please.
Thank you, Your Honor. Attorney Josh Hadley, appearing on behalf of defendant probationer, Mr. John Martinez, who stands to my right. Mr. Martinez, please state your name for the court.
Good morning, Your Honor. This is John Martinez.
Thank you. Today is the day and time set for the probation violation hearing. This court is in receipt of a memo from Officer Grant indicating that Mr. Martinez has failed to enroll in substance abuse treatment, failed to provide documentation of probation, tested positive for THC on September 6, 2023, failed to appear on September 16, 2023, and September 25, 2023. He failed to begin community service or provide any documentation to probation, has failed to maintain his payment plan. Mr. Hadley, what say you in response to this violation information?
Your Honor, we would plead response. I'm sorry, I had a chance to review the violation information with my client, advising of his rights. As to the test, the positive test for THC, we would plead responsible to technical violations. As to the failure to enroll in substance abuse, Your Honor, that actually has been addressed now. There's been documentation that was provided today to confirm that that has been complied with. Additionally, it's my understanding that there's been documentation provided to the probation department that 12 of the 24 hours of community service have been completed as well at this point. So, Your Honor, I think that, I'm just trying to make sure I'm reading that those are all the VOPs. Substance abuse.
Payments.
Payments. And I guess we would also then plead responsible to the discontinuing of the payment plan, but then note to the court that Mr. Martinez will be making payments.
Any comment, Mr. Grant?
No, Your Honor. He had originally been scheduled to test with JAMS. We switched him over here. He did appear. I do not have the result for that, which that's still pending. It was just last week that he came in here. He did provide me with substance abuse. He did provide me with community service. So my recommendation is that we set it for a review 30 days out.
Thank you. Court accepts the plea of responsible to the technical violation of testing positive for THC. The court will adopt the recommendation made by Mr. Grant and set this matter for review. The November 13th date is too soon. Do you have the next date after that? You don't.
I think it's that first, is it the first Monday in December? I think November is the only. I promise you I will next time.
Do you already have things set on that date? It would be December the 4th, maybe. Mr. Martinez, I just don't want you to leave without that new date. So give us a moment. Let's see if we can find.
I believe it is the 4th. Yeah.
I'm double checking to see if you already have some stuff scheduled, Mr. Grant. Oh, we have to fix that. There's a jury trial scheduled on December 4th. On a probation thing? I'm looking at it. Mr. Grant, we'll have to fix this. We have a jury trial scheduled on that Monday, the 4th of December. That's not typically how we do things. Thank you. Mr. Martinez, if you would be so kind, sir, have a seat. Ms. Rapp will be back with that next probation date. It's okay. If you would write down the number, we'll check when we go back. 230611. It's a date with Ms. Mandernack. On December the 4th, a Monday at 8:30. It's not, and that's why. We'll get back to it. And I'll put Mr. Martinez on the side until Ms. Rapp is back. I gotta stop calling her Ms. Rapp until she's back with the new date. Mr. Hadley next, please.
Absolutely, Your Honor. We are all set to go on Miss Amanda Bias. Miss Bias, please come on.
Thank you. 220279 FY, State of Michigan versus Amanda Bias.
Good morning, Your Honor. Attorney Josh Hadley, on behalf of the probationer defendant, Miss Amanda Bias, who's standing to my right. For the record, please state your name.
Amanda Bias.
Thank you, Ms. Bias. Today is the day and time set for the violation hearing. This court is in receipt of a violation information from Mr. Grant indicating that you have failed to maintain your payment plan to pay off the restitution, and you in fact owe $1,213 in this matter. You have not had contact with the victims. There are no new offenses on your driving record or your criminal history. Mr. Hadley, what say you in response to this violation information?
Your Honor, after reviewing the violation information with my client, advising her of her rights, we would plead responsible to the technical violation of failing to pay off the remaining fines and restitution amount of $1,213, and would indicate that Ms. Bias and I had discussion about how this going to be resolved, and I believe it's not like hopefully employment maybe as soon as the next couple of weeks. So actively still looking for employment with positive leads.
How do you support yourself, ma'am?
My mom lived with me and she was helping me.
Any comment, Mr. Grant?
Your Honor, I know I've been working with Ms. Bias as well. We even got her enrolled in the SOS Community Service Program here at the court. So I'm optimistic that she will get some sort of employment and start making payments. Outside of that, she's done everything that's been asked. She's never missed a report date. It's just financial is her problem.
Are you requesting a review date of any
Yeah, we
kind?
can do a review date, Your Honor. December 4th.
Is that really the date?
Yes, Your Honor.
I'll look at it later. I'm sorry. That's Ms. Bias, we'll set a review date for you of December the 4th, 2023 at 9:30 a.m. live back here again in courtroom number 1. If you resume payment and Mr. Grant is satisfied with the progress you make between now and then, he has the ability to cancel that hearing. So get employed, start making payments, or have conversation with him about some other way to proceed, okay?
Okay.
Anything else, Mr. Hadley?
No, Your Honor.
Thank you. You're free to go.
Actually, Your Honor, just one brief moment. I'm sorry. I apologize.
Can we just bring it to the court's attention that Mrs. Bias did just inform me this morning that on Thursday she was arrested in Westland, but no charges were filed. I have no information other than what Ms. Bias just told me.
My understanding would be the same, but the matter was dismissed. There was a family dispute between sisters. I believe law enforcement may have taken people away to let the
Cooler heads
cool,
prevail.
and then
Mhm.
everyone was released without pending charges, is our understanding. We just didn't want the court to think anyone was trying to hide the ball because there had been police contact. It just didn't result in new charges.
Understood.
So.
Thank you for that information, Mr. Hadley. Ms. Bias, good luck to you. Have a good day.
Thank you. You too.
Mr. Martinez, same thing for you, December 4th, 2023 at 9:30 back here in courtroom number 1. Have a good day, sir.
Your Honor, we're all set to go when the court is ready to hear us on Robert Cronenwit.
Mr. Cronowit. Good morning, Mr. Mays.
Good morning, Your Honor.
What are you here for, sir?
John Dawson. Angela Manarino and I have an agreement already worked out. She just needs to send in the paperwork. If you could ship me on over to her, please.
I'm on a probation violation docket, Mr. Mays. I'm not sure.
Maybe I've got Judge Green. I'll log in over there, Judge.
Thank you.
Thanks, bye.
230027 FD. This is State of Michigan versus Robert Cronenwit. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of the probationer defendant, Mr. Robert Cronenwit, who's standing to my right. Please state your name for the record, sir.
Robert Dean Cronenwit.
Thank you. Today is the day and time set for the violation hearing in this matter. The court is in receipt of violation information from probation officer Anthony Grant that indicates that Mr. Cronowit tested positive for alcohol on October 3rd, 2023, on October 5th, 2023, and had abnormal creatinine levels on October 10th, 2023, and October 11th, 2023, that Mr. Cronowit did pick up his alcohol monitor on October 13th, 2023, and then missed a test on October 17, 2023. Mr. Hadley, you were not present when Mr. Cronowit was sentenced on October 2nd, 2023 in this courtroom. And this court had conversation with both Mr. Cronowit and his attorney, Kerry Martin, because Mr. Cronowit had appeared here in this courthouse under the influence of alcohol sufficient that Mr. Grant had to seize his keys. At the time of his sentencing, Mr. Cronowit was advised by this court specifically that there would be zero tolerance, that if he tested positive, the consequences would be dire. That being the case, and you having had the opportunity to speak to him this morning, how are we proceeding, sir?
Your Honor, obviously wasn't aware of the information that you just let me know outside of kind of what my client and I had shared with one another. As to the positive test, we would plead responsible to the technical violation. Your Honor, I think as I'm looking at the other VOPs, I'm seeing a positive on the 3rd and the 5th, and then diluted. So I guess we would be pleading responsible just as to the 2 positive tests. I believe those are the only allegation. I'm sorry, and a missed test on the 17th. Your Honor, and as well to the missed test.
Thank you, Mr. Hadley.
In the way of allocution, what I would ask, Your Honor, is that we're kind of in the infancy stage of this period of probation. He's got a long haul in front of him. If he's going to be able to comply with the conditions that the probation department has put on him at this time, he stands before this court saying, you know, this was a regrettable situation. He was aware. Again, the court has told him zero tolerance. But what I think is more important at this point is that the monitor is in place, and we do have a system where there's not missed tests, diluted tests, everything else. There is a reliable way of having this monitor moving forward. We would just ask the court to consider that when trying to determine what the appropriate outcome will be for this individual, is to say, please a control date 60 days out to give the proverbial rope for one to possibly hang oneself with, or to demonstrate to this court that this was a hiccup at the beginning of a recovery process that won't be continued as the probation period continues.
Thank you. Mr. Grant.
Your Honor, the probation department doesn't object to a 30 or a 60-day review. But I just want to make note that I have not received to date any of the other necessary paperwork. We're coming up within the 30 days, which would be 11/2, I think is my 30-day mark for documentation on everything else that's requested. So I asked Mr. Cronowit to get that to me as soon as possible.
And just briefly, my client did just address that between ourselves here at the podium. We would agree that those need to be taken care of immediately, and he does have every intention of going out and doing that. Again, if this court would find it within your discretion to allow this individual understands clearly what that would look like moving forward with coming back to this court and not having those programs started up with Mr. Grant.
Thank you. The court accepts the pleas of responsible to the positive test and the missed test, and will accept the recommendation from Mr. Grant to set this matter for review on December 4, 2023 at 9:30 a.m. back here in courtroom number 1. Mr. Cronowit, we had lengthy conversation when Mr. Martin was present previously about what's going on, and Mr. Grant wanting to be supportive of your efforts at abstinence from alcohol, trying to say that as delicately as possible. This court's inclination, should you continue to test positive or otherwise fail to be compliant with the probation sentence that you've received, is to send you to jail. That is not something this court takes lightly. It's not something this court does often, but if you continue to violate the terms of the sentence that was handed down not even a full month ago, the court will take it as your unwillingness to be compliant and will respond accordingly.
Yes, Your Honor.
Anything else, Mr. Hadley?
No, Your Honor, on behalf of my client, thank you very much for giving us at least the opportunity to kind of hear us out today. And we look forward to the compliance date here on December 4th.
Thank you. Good luck to you, sir. Have a good afternoon.
Thank you, ma'am. Your Honor, I now have, I believe, this will be our last one that I've met with. It'll be Robert Matthews.
That can't be the last one. I have 3 files left. 220160 SM, State of Michigan versus Robert Matthews.
Good morning, Your Honor. Attorney Josh Hadley, on behalf of the defendant, Mr. Robert Matthews. Please state your name for the court.
Robert Matthews.
Thank you. Today is the day and time set for the violation hearing in this matter. This court is in receipt of violation information from probation officer Shannon Rapp. This case was previously adjourned for 30 days for Mr. Matthews to become compliant with his anger management program. He additionally owes the court $1,890 for the fines and costs imposed in this matter. He has not made a payment since February 9th, 2023. He's granted the opportunity to complete community service in lieu of fines and costs due to financial difficulties that he indicated to Ms. Rapp. He's failed to provide any hours of community service as of the report dated October 23rd. He completed one of the 13 classes that he was ordered to complete. He was discharged from the program because of his inactivity. Mr. Hadley, how are we proceeding in this matter this morning?
Thank you, Your Honor. I would agree that this was adjourned to show compliance with the anger management program. It's my understanding, speaking with Mr. Matthews, that in fact has been restarted. Mr. Matthews did pay the reinstatement fee with all the extra tag-ons. It's about $63. And in fact, last Friday completed a class with Pam's Place. So we are happy to report back that issue has been resolved. I think we would still be pleading responsible, Your Honor, to the technical violation as that wasn't done within the allotted time, but he has been able to, as I stated, get it completed now, and he's back enrolled. We discussed the issue of the outstanding fines because I know that we previously had asked to convert this into community service. Mr. Matthews is employed full-time at Prefix Corp in Auburn Hills. So we're happy to report he's earning again, but I believe we would now be back into trying to make payments. His work schedule is such that with the hours he's keeping, the community service that's been provided doesn't really fit with the hours that he has. So we would, again, ask the court allow him until that March 16th, 2024 date to make good on the monies owed. So I think a review date would, again, that's what we're humbly asking for, just to allow Mr. Matthews to provide one documentation, have the documentation from Pam's, that's what they were saying. So Pam's Place had indicated that they were going to be getting the paperwork to the probation department. I've advised my client to take the next proactive step and reach out to Pam's Place today to tell them, please send that information over to the probation department to satisfy that.
Mr. Matthews, how long have you been working, sir?
It'll be a year on 4. Well, no, it was, I made my first year at Prefix on the third of this month.
Ms. Rapp?
In addition, the defendant originally engaged into the program in November of 2020. Completed 2 classes, then it was closed out April of 2023 due to non-compliance and him not attending the classes. Again, he would re-enter the program in June 2023. He attended 1 class, and in August of 2023, they closed him out for non-compliance with classes. So this would be the 3rd time the defendant has re-engaged into the program. We did extend his probation out 6 months. But again, this is the 3rd time that he is re-entering the program with only completing, this would technically complete that one would only be 4 classes. So probation would recommend adjourn one more time for compliance, and if the defendant is not compliant at that time, then recommendation for jail.
And if I very briefly may, Your Honor, it's actually our position. We believe there would be documentation from Pam's place that would indicate there was actually 6 classes that may have been completed that first pass through. Not trying to mitigate it, again, what Ms. Raffett stated about the engagement, disengagement, re-engagement, that stands to be true. We do believe he's completed more of the courses. And again, if we're able to get that information over from Pam's place, we'll get it to the probation department as quickly as we possibly can.
Thank you for that clarification, Mr. Hadley. Mr. Matthews, this court's concern and the reason why the question was asked, how long you've been at that job, was because you appeared in this court on October 31st, 2022, so not quite a year ago, indicating that you wanted to do community service in lieu of fines and costs. And the court said, absolutely not a problem, because this court's desire is for you to be successful on probation. You've been on the job for a year. You haven't made a payment in this matter in 8 months. That suggests to the court that you're not taking it seriously and you don't intend to be compliant, given the leeway and latitude that the probation department has recommended for you. That being the case, the court will accept the plea of responsible to the technical violation, set this matter for review on December 4th, 2023 at 9:30 a.m. back here live in courtroom number 1. There is a notation in the file that should you remain non-compliant, both with resuming a payment plan and providing documentation showing that you have completed the class, it will be jail in lieu of additional conversation or adjournments. Anything else, Mr. Hadley?
No, Your Honor, thank you, and we understand the court's message.
Thank you. Anything else, Ms. Rapp?
No, Your Honor.
Good luck to you, sir. Have a good afternoon. Why in the world would we say jury trial on Monday?
Josh, I did, you heard that you was
I know it's right, but it's.
so once you're late, you have to start over.
All right, so you're not gonna make credit for those. Yes, she said that she.
I did get that you're re-engaged. I didn't get that you attended any classes, but that you were reinstated. So I'll email her back and if you attended that one class. Okay.
You found your missing one?
I did. My apologies, I think Mr. Reed was like, no, that's not the last one.
Is-
Derek Reed, sorry about that, Mr. Reed. I felt the eyeballs doing, no.
Well, I know that we'd had this before where Mr. Reed had been stuck in traffic and did everything, yeoman's effort to get here. This is 230489 SD, State of Michigan versus Darren Scott Reed. Your appearances, please.
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of probationer defendant Mr. Darren Scott Reed. Please state your name for the record. Darren Scott Reed.
Thank you.
Your Honor, I've had a chance to review the violation information with Mr. Reed, as well as advise him of his rights. I guess I'm breaking this into 3 separate, up on the top part here. There's a failure report on October 4th. There's a failure to be fingerprinted on September 25th. And then there was an alleged new case out of Huron Township for a felonious assault that occurred on 9/11. Your Honor, as the failure to report, we would state that that's accurate. However, Mr. Reed's position was that he had not received or had not had communication with probation at that time. I believe, as he stated, he reached out, I don't have an exact date.
9/25.
Okay, so yes, we would state that there was a failure to report, but I believe it was a miscommunication. I don't think that there was any, again, intent to be missing anything. As it relates to the fingerprints, Mr. Reed has been fingerprinted with the Huron Township Police Department. We're not sure if he needs to go back to be specifically fingerprinted as to this case file, but they do have his fingerprints from a different matter. And I did confirm, we pulled up the register of actions. There were some old cases that were previously dismissed in 2022. And it does look like he was arraigned and would have got fingerprints done on those. So we will comply. We're not trying to play games. If they need his fingerprints on this file, he'll go over and take care of it today. But I think that was the basis for why he hadn't gone back over. They need him on each case to get, okay. We plead responsible. He'll go over and get fingerprinted today, Your Honor.
And as for the felonious assault,
We're gonna go ahead and deny that. There's been nothing received by Mr. Reed from Huron Township Police Department or any prosecutor. We know that'll be the Wayne County Prosecutor's Office on this one. And in fact, Mr. Reed's indicated to me that he would have, sounds like very solid alibi evidence that he was actually in Sturgis, Michigan on September 11th. Would be able to prove that as such. I tried to look this case up on the ROA to see if there was anything tied to this. I'm not finding anything about the Huron Township case.
Mr. Grant,
To start with, I guess, the not knowing that he was supposed to report, I sent him multiple emails, I've sent phone calls. So that's not true. As far as the fingerprints goes, there was an order in that exact email letting him know that he does need to report to the Huron Township Police Department for those fingerprints. To address the felonious assault, I got a copy of the police report. As far as him being in Sturgis that day, he was actually in his courthouse that day being sentenced. And then he has not registered at JAMS for testing. He has not started his community service. He has not started his substance abuse treatment. I've not been able to make contact with Mr. Reed since he left this building on 9/11.
what's your recommendation?
I would recommend that we add at least 8 hours of community service to his total of 24 and set it for a review at the earlier date on November 13th for compliance.
Mr. Hadley,
Yeah, briefly in response, Your Honor, we would, after speaking with Mr. Reed here at the stand, he would state that he was in this court the morning of the 34th. I'm sorry, that he was in 34th District Court the morning of the 11th, but he was in Sturgis. He left here and went to Sturgis. So I guess we're shooting in the dark a little bit. We don't know when or where this alleged felonious assault occurred or took place. So if we're not trying to mislead the court, he just knows he was either here or on his way to Sturgis is his assertion. As it relates to the failure for communication, it's my client's position. He actually didn't receive any of these emails. That's what prompted him to reach out and make the phone call. We're not disputing what Mr. Grant's stating. My client's just saying, I didn't receive said emails, is our position.
as for the felonious assault, so Mr. Grant has made the record that he is in possession of a police report that indicates that your client, Mr. Darren Scott Reed, on September the 11th, 2023, in Huron Township, engaged with law enforcement sufficient that a police report was generated and the allegation was felonious assault. And is your client's position, or at least through you, that that didn't happen?
That is correct.
No contact with police on September 11th.
Your Honor, at this point, as far as the no contact with police, Mr. Reed had left the scene prior to the police arriving, but he is named as the suspect in that felonious assault report.
Suspect, so no actual charges.
When I talked to the Huron Township Police Department, the charges were sent over to the Wayne County prosecutor and are pending.
That being the case, Mr. Reed, what the court will do is adopt the recommendation made by Mr. Grant and add 8 hours of community service to your existing time. We'll set you for a review on November 13, 2023 at 9:30 a.m., back here in courtroom number 1 in person for continuation of this hearing. Between now and then, sir, you need to appear in Huron Township to be fingerprinted on this specific case. The things that you have not yet started doing, please start doing. And if, without going into whatever conversation you had specifically with Mr. Hadley regarding the events of September 11, 2023, if there's the possibility that there are additional criminal charges out there against you, this might be a time to try to get ahead of it in terms of getting it resolved or following up with whomever you need to follow with. I'm assuming that if you've been indicated to be a suspect, there's been some attempt to at least be in contact with you regarding those events. You don't need to respond to it at all. I'm just saying for people to say, I didn't know, or I haven't been formally charged yet. Waiting until that warrant is issued is usually the beginning of an additional case in this court versus getting in front of it and resolving it.
Mr. Grant just shared a little additional information with me about these, the new allegations. I'll let my client know kind of what's going on, so maybe we can get a little more clarity as to what that allegations actually.
Thank you, Mr. Hadley. Anything else?
No, not this time, Your Honor.
Thank
Thank you.
you.
I do apologize. I'm sorry. The review date was the earlier one. It was November.
The 13th?
13th, okay.
Back at 9:30?
Perfect. We're all set to go, Your Honor. Thank you.
Thank you, Mr. Reed. Have a good day. We have remaining 1500570M. This is Van Buren Township versus Stacy Dunn. This case was scheduled at 9:30 a.m. for a violation hearing. The violation information provided by Mr. Grant indicated that the defendant failed to complete the 4 days of community service. Failed to provide documentation for the Salvation Army inpatient substance abuse treatment. Failed to maintain her payment plan. She owes the court $1,594 in this matter. She was picked up on a warrant in Van Buren Township on October 3rd, 2023, and given the show cause date of today, October 23rd. Case having been scheduled at 9:30, it now being 10:24 by the court's clock, defendant having failed to appear, court will issue bench warrant in this matter unless, Mr. Grant, you have some update as relates to Ms. Dunn. I'll take that as a no. Bench warrant shall issue in this matter 5,010%. Lastly is 220381 FY State of Michigan versus Blake Metzger. This matter was scheduled at 9:30 a.m. It's now 10:25 a.m. by the court's clock. This was not actually a violation hearing. It was more of a error in updating this matter when Mr. Metzger appeared on July 31st, 2023. This court ordered that probation be closed successfully and that a payment plan be set for the remaining fines and costs that were due in this matter, that total amount being $850. However, there was an oversight to the fact that this case was under 769.4A, which means that it could not close it accordingly. Probation Department has made multiple efforts to be in contact or communication with Mr. Metzger to correct this error. He has failed to respond. Notice was sent to him to appear this morning. He has failed to appear. Ms. Rapp, what do you propose?
In addition to trying to contact the defendant multiple times, he also failed to contact the collection department to set up payment. So probation is respectfully recommending that the defendant that file both warrants with the conviction after.
Thank you. Defendant having failed to appear at 10:27 a.m., conviction shall enter. Bench warrant to issue 5,010%. Anything else, Ms. Rapp?
No, Your Honor.
Thank you. That concludes this matter. I'll give the file to Officer Brooks. That is the last thing scheduled this morning. Andy, is there anything else from the police departments? We'll take that as a no. That concludes this court's docket. We stand adjourned. Thank you, Mr. Hadley.
Thank you, Your Honor.